Today I will be discussing ethical conundrums that are present in the legal system, as I am a criminal justice major on a pre-law track. Okay. Ethical conundrums that might arise in the courtroom. Criminal justice system, the legal system especially, presents various ethical dilemmas, and many of them are still debated. This is due to the fact that the criminal justice system is responsible for determining the outcomes of victims and those that are sentenced. So, the actions taken by the people in the system carry a very heavy weight. Judges, lawyers, and even jury members have a responsibility to consider cases in depth and with seriousness, because the outcome of the case will affect all parties involved. When this responsibility is not met, ethical dilemmas arise. But even greater than this responsibility not being met, the composition of the legal system itself presents ethical dilemmas. There are a few different ethical dilemmas that are widely debated about the legal system, some of them being conflict of interest. Is it ethical for a party involved in a case, like a judge, jury member, or lawyer, to be involved in the case if they have a conflict of interest? Penalty and sentencing. Is it ethical for the government to sentence someone to extreme conditions like death or life in prison for crimes that they've committed? And plea bargaining. Is it ethical to offer plea bargains for a case knowing that the defendant might plead guilty regardless of if they are or not, just to avoid the risk of a harsher sentence? So, the ethical dilemma that I will be discussing today is it ethical for the government to sentence someone to extreme conditions, such as death or life in prison, for crimes they have committed? I kind of have a personal interest in this question, which is why I picked it. I think that the death penalty is just something that it gets debated a lot about how ethical it is, and it's the type of thing that there's not really just two positions on it. There's not two sides that are argued. It's such a wide spectrum. There's so many stances that you could take on it. So I wanted to start off by reviewing the history of capital punishment. In 1800, before the Common Era, the first recorded laws regarding the death penalty were established in the Code of King Hammurabi in Babylon. This is the first instance that the death penalty is written. We have nothing recorded before that regarding it, even though I'm sure it did exist. But this is the first instance that it has been written into the law for a society, so I wanted to include that. In 1066, now in the Common Era, William I of England outlaws hanging or other execution except for in time of war. This is the first instance that we see governments taking a step away from the death penalty. Even if they're still using it in times of war, they're trying to avoid that severe of a punishment. In 1087, after William I dies, his son takes the throne, William II, and he reinstates capital punishment. So here we see the government going back towards it. In 1509, time skip a little, the number of capital crimes continues to rise in Britain, and there is now 222 crimes punishable by death. In 1607, we have the English settlers moving over to the Americas, and they bring with them the practice of capital punishment. And then a year later, in 1608, Captain George Kendall of the Jamestown colony in Virginia is the first person to be executed in the Americas. In the British colonies. In 1767, Caesar Beccaria claims that there's no justification for the state's taking of a life in his essay on crimes and punishment. This sparks a huge rise against capital punishment and starts the abolitionist movement towards not including it in the law. In 1779, Thomas Jefferson has been inspired by this essay, and he introduces a bill to revise Virginia's death penalty, proposing that capital punishment only be used for the crimes of murder and treason. This law fails to pass. In 1794, Pennsylvania is the first state to repeal the death penalty for all offenses except first-degree murder. And in 1829, many states reduce the number of their capital crimes and build state penitentiaries. So we see most of the states moving away from using capital punishment as a punishment for crimes. In 1838, there's an effort to make death penalty more palatable to the public, and states pass laws against mandatory death sentencing and instead enact discretionary death penalty statuses, which just means that when someone is convicted of a crime that used to be a capital punishment, now it is up to the judge and jury's discretion to decide if they will receive that capital punishment or a lighter sentence like life imprisonment. In 1846, Michigan becomes the first state to abolish the death penalty for all crimes except treason. Rhode Island and Wisconsin abolished the death penalty for all crimes. And then in 1863, with the exception of a small number of crimes that weren't committed often, all mandatory capital punishment laws have been abolished. So now it is completely up to the discretion of those in the courtroom. In 1890, after the Civil War, new developments for executions emerge. The electric chair is introduced in New York, and other states adopt this method as their primary form of capital punishment. In 1920, following the start of World War I, we see a large rise in the use of capital punishment again, out of fear. And 5 of the 6 abolitionist states reinstate their death penalty. In 1924, the use of cyanide gas is introduced because Nevada was seeking a more humane way to execute inmates, and the gas chamber was constructed as a result. In 1930, a resurgence in the use of the death penalty emerges, and it really starts in the 1920s and carries out to the 40s as a result of the First World War, due to the writings of criminologists who argue that the death penalty was a necessary social measure to keep society safe. In 1966, the public turns away from capital punishment, kind of in disagreement with the states. The law is enforcing it, but the public isn't really liking that. And a Gallup poll shows that support for the death penalty is only at 42%. In 1968, the Supreme Court begins fine-tuning the way that the death penalty is administered. And in 1972, the death penalty is actually challenged in a Supreme Court case, Furman versus Georgia. The court holds that the statute is cruel and unusual and violated the Eighth Amendment. In 1972, just after this occurs, the Supreme Court effectively voids 40 death penalty statutes and suspends the death penalty because the existing statutes were no longer valid. In 1973, 34 states in favor of the death penalty enact new death penalty statutes that work in accordance with the Supreme Court's ruling by providing sentencing guidelines as to when the death penalty should be sentenced. In 1976, guided discretion statutes are approved by the court, reinstating the death penalty in Florida, Georgia, and Texas. And the Supreme Court holds that the death penalty itself is constitutional. In 1988, a new federal death penalty statute is enacted for murder. The statute is modeled on the post-Gregg statutes that the Supreme Court has approved. In 1994, President Bill Clinton signs the Violent Crime Control and Law Enforcement Act that expands the federal death penalty to 60 crimes. And in 2007, New Jersey is the first state to repeal the death penalty by vote since Gregg versus Georgia, followed by several other states. Governors in these states suspend all death sentences. By 2019, Attorney General William Barr orders the resumption of federal executions, and there are 5 executions scheduled over the next year. In 2020, we see one of these executions take place, and the federal government executes Daniel Lee Lewis, who's the first convict executed by the federal government since 2003. And now in modern times, 2025, we see President Donald Trump sign an executive order ending the federal moratorium on executions, and he directs the Department of Justice to seek the death penalty for certain crimes. So that was a brief summary of the history on the use of capital punishment, mostly in the United States. But there are various factors that should be considered when deciding on a stance. Factors like governmental power and control. Is it morally permissible for the state to take a life, even as a form of punishment? And why does the government hold this power to determine if someone lives or dies? There's the risk of wrongful sentencing. What's the risk of a wrongfully convicted person being executed? And does the risk of this outlaw capital punishment? Equality during conviction. Are death sentences applied based on race, gender, income, geography, and legal representation? And do these systemic biases undermine legal legitimacy? Are people being executed unfairly? Societal well-being. Does sentencing these criminals to death make society safer? And does implementing capital punishment reduce crimes committed, thus bettering society? The right to live. Should the right to live be inalienable by the government? And does one forfeit this right by committing a capital crime? Severity of crimes. Should punishment match the severity of a crime? So, thus, are homicidal crimes deserving of death? And if so, are non-homicidal crimes deserving of death? Due process. Are trials, appeals, and clemency processes robust enough to ensure fairness? And are defendants given adequate defense resources in these upcoming trials? Cruel and unusual punishment. Are execution methods humane or prone to cause suffering? And is the least cruel method of execution still ethically acceptable or not? And alternative punishment. Is life imprisonment a sufficient and ethical alternative? Or is life imprisonment more or less ethical than the death sentence? These are all factors that should be considered when you're deciding your stance on the death penalty, and they're all factors that are used when determining the position. We have two major positions that are present in this argument. There's retentionism, which is in support that capital punishment is ethical, and there's abolitionism, which claims that capital punishment is unethical. The retentionism position supports the use of death penalty as an option for punishment of the most severe crimes, with the belief that it delivers appropriate retribution and protects society by permanently removing dangerous offenders. For retentionists, the severity of certain crimes justifies the state's use of a severe punishment. Whereas the abolitionist position claims that the death penalty is unethical and should be eliminated. They argue that the risk of executing the wrongfully accused, as well as systemic biases, like race, wealth, and legal representation, make capital punishment unjust. Abolitionists hold that the taking of a life, even as punishment for a crime, violates human rights. The response that I will be defending today is the retentionism perspective. My first premise is that a just legal system must impose punishments that are proportionate to the severity of crimes committed. This is supported by the fact that proportional punishment ensures fairness and upholds the moral balance of society, and the fact that when punishments are too lenient, the justice system fails to condemn the moral gravity of certain crimes. My next premise is that some crimes, such as premeditated murder and acts of terrorism, are so morally extreme that no punishment short of death could be considered proportionate. This is supported by the fact that these crimes involve intentional, irreversible harm to innocent victims, the fact that the severity and intentionality of these crimes distinguish them from all other categories of wrongdoing, and the fact that the harm of committing these crimes is equivalent to the severity of the punishment of death. My next premise is that a justice system must also protect society from individuals who pose an unmanageable and ongoing threat. This is supported by the fact that certain offenders have demonstrated a consistent willingness to harm others and can't safely be rehabilitated, and the fact that execution permanently prevents further harms from occurring when other containment measures, like life imprisonment, may still carry risks, such as the inmates escaping or harming those in captivity. My fourth premise is that punishment should reinforce moral norms and communicate society's condemnation of extreme wrongdoing. This is supported by the fact that the death penalty signals the highest moral denunciation of the most heinous crimes. My final premise is that victims and their families have an interest in seeing justice delivered in proportion to the harm suffered. This is supported by the fact that the justice system exists partly to acknowledge and validate the harm done to victims and support them, and the fact that for some victims' families, the death penalty can provide a sense of closure, moral recognition, or finality. In conclusion, the death penalty should be retained as a legal option for punishing those convicted of severe crimes. I think that's all I have to say. Yeah. I honestly don't actually know what side I take. I argue the retentionist perspective because I feel like there's a lot of evidence going both ways. But to an extent, I do agree with the death penalty. I just don't think that it can exactly be morally applied in the legal system that we have going on right now. I think a way that we could make it more ethical is by adding cross-examination to the trials that lead up to the sentencing, or not up to the sentencing, after the sentencing, before enactment of punishment. I think that being cross-examined at a higher court would do a good job of ensuring the evidence is accurate and that the conviction is correct, to avoid any sentencing of wrongfully convicted individuals. But yeah, it's kind of like a weird in-between. I don't really think it's exactly ethical or unethical. But yeah, that's my dilemma. I guess that just shows that it really is a dilemma because I can't decide. But yeah, thank you. I'm sorry this video was late. I'm kind of trying like not to die right now. Yay. Please give me a good grade.